part of Haven, and these Haven half times, I think, are a lifeline for a lot of us to be able to just be able to interact with people once again, other than those in our own family, right? So like you, I've been spending a good portion of my time taking webinars, reading articles, listening to news reports, and as an attorney to small businesses, there's one thing that's on the forefront of my client's mind and on mine, and that is, how do we mitigate our losses here? Business owners are being prudent, and they're turning over every rock that they can in order to survive. And that's one reason why we're talking about business interruption insurance today. A few weeks ago, I spoke about workplace issues during COVID-19. I focused on legislation, expanding FMLA for workers, and how to manage your workforce through work share programs and unemployment during this time. I also raised other issues such as contractual obligations and ways to delay or excuse performance, and a cursory raising of the issue of business interruption insurance policies. And then in the various webinars that I've taken since then with the Connecticut Bar Association and the American Bar Association, I've noticed that it's an issue that is raised, but it's not fully fleshed out because nobody really knows how this is going to work in this scenario. It's a murky area. I've tried to gain some clarity on it, but it's made even murkier because a virus is not a typical disaster scenario. The typical ones are fire and war and act of God, you know, those that are they're resulting in a physical loss, and viruses are silent, right? But here we are 1 month later with businesses closed, and the effect, it could be argued, is the same as an act of God or fire or water or war. So how does business interruption insurance come into play here? So Felicia and I felt like we really needed someone well-versed in insurance law to give all of us a primer and a realistic perspective on business interruption policies. She and I both know Kelly Franco of Franco and Associates. Franco and Associates is based in New Canaan. I think Kelly's been there for 14 years, and she practices specifically in the area of insurance litigation, representing insurance companies. So we have an insider here. She is presenting today to give Haven members and area business owners a realistic look at business interruption policies, and a thought process and steps that you can take to try to determine if this is a policy that could apply, and a policy through which you can file a claim. So at this point, I'm going to hand it over to Kelly to give us the data. Thank you.
Thank you, Alexis. I really appreciate the introduction. Everybody can hear me okay? We're good, awesome. My name is Kelly Franco, and I am here to talk about business interruption insurance as it relates specifically to COVID-19 losses. Appropriately, I am hosting this seminar from here in my house, since we're all trying to stay home, and I trust you are all in your houses as well. I think the only thing that could make a seminar on insurance coverage even drier is to give it in the isolation of one's hermetically sealed home. So here we are doing that. We're on Zoom, and so here's to a strong internet connection. Short introduction, as Alexis so kindly said, I am an attorney with my own boutique firm in New Canaan, Connecticut. I have been practicing insurance coverage and defense work for over 2 decades, and I also practice probate litigation and civil litigation. So if you're a small business person who has suffered financially within the last month, and believe me, a lot of us have, you might be, as Alexis said, trying to turn over every rock and see what recourse you can find. And maybe you have thought about business interruption insurance, that policy you had that you thought might have some recourse for you for the losses you've suffered due to COVID-19. Maybe you've been asked, gee, do you have a virus exclusion in your policy? And you didn't really know what that was. Maybe you wondered what that was. Maybe you picked up your policy to try to read it, and chances are you may have found it rather convoluted. They're not the easiest things to understand. So this is a dry topic, and I will do my best to make it interesting and understandable. What I'm telling you is not legal advice, since Every analysis is highly dependent on the language of your individual policy. But what I hope to provide you is some guidance as to issues to consider if you're going to speak with your insurance representative or maybe your own attorney. So maybe you heard about the virus exclusion. Maybe you looked in your own business interruption policy and you didn't see an exclusion for losses caused by viruses, and you thought, fantastic, I'm home free. But unfortunately, that's not 100% how it works. Just because a loss is not excluded does not mean that it's covered. So the first thing I'm going to do is take you to insurance coverage school. You're about to learn more about insurance coverage than most attorneys know. An insurance coverage analysis is based on 3 questions. First question is always, is the loss covered? Is it covered under the insuring agreement? If yes, you go to the second question. Is it excluded? If it's excluded, there's no coverage unless, question 3, if it's within an exception to an exclusion. So just to go through again, number 1, is it covered under the insuring agreement? If it's not covered, game over, no coverage. If it is covered, you have to look at whether it falls into an exclusion and whether it falls into an exception to an exclusion. So let's take these 3 steps and look at specific hurdles to coverage that you might face for COVID-19 claims. So I told you that the first step in determining whether or not there's coverage is whether your loss is covered under the insuring agreement. And it's this word, loss, that is going to be your biggest hurdle right out of the gate. So business interruption policies are usually cover 2 main areas. The first area that's covered are building and property. So if you can imagine a building burned down by fire, you would look to your BI coverage to replace the building. But what most of us are looking at with respect to COVID-19 claims is this business income coverage, which is the other part of the business interruption policy. We're looking for whether or not we can recoup our business income. So like I said, the first element in determining whether or not your loss is covered is to look at the insuring agreement. So an insuring agreement for your business income coverage is likely to read something like this. This is from an actual policy. We will pay for the actual loss of business income and rental value you sustain due to the necessary suspension of your operations during the period of restoration. The suspension must be caused by direct loss to property at a premises caused by or resulting from any covered cause of loss. Rolls off the tongue like the lyrics to your favorite song, doesn't it? So that's insurance policy speak. And this term loss is going to be the fly in the ointment in determining whether or not you have coverage for your losses. Loss in your insurance policy is probably beginning with a capital L or written in all caps or in quotes or in bold. And what that means is that you can't just use the dictionary definition of loss. You have to look at the policy definition and use the policy definition of the word loss. Loss in your policy likely means physical loss or physical damage. And this is going to be the key to policy analysis and whether or not there is coverage. If you do not have physical loss or physical damage, you are not going to be within the insuring agreement, and that step 1 of insurance coverage that we talked about is not going to be fulfilled. There's not going to be coverage. Business interruption coverage was designed to provide coverage for losses sustained due to physical loss or physical damage. And it's going to be a hurdle to show that the losses your business sustained as a result of COVID-19 are physical loss or physical damage. it's likely that your business was shut down or modified or restricted to contain the spread of COVID-19, but not because of physical loss or damage. So in that situation, there is not going to be coverage because you're not going to fulfill the definition of loss. And so you're not going to have a loss under the definition in the insuring agreement. But as I thought about this issue, and there's a lot of thinking to be done here because these are going to be issues of first impression, as we call them, for courts, when courts have to decide issues that they haven't had to decide before. And seeing as we're facing a situation we haven't faced since 1918, I think that there are going to be some decisions that the courts have to make. And one issue that I spotted was, I thought about whether or not if your office suffered actual contamination, whether or not that could be considered physical loss or physical damage. Because if you suffered actual contamination as opposed to shutting down because of a fear of contamination or a prophylactic shutdown to stop the spread of the disease, if you suffered actual contamination, I think you could have maybe a better shot at a court interpreting that to be a loss pursuant to your policy. So later on, when we talk about making claims, if your building suffered actual contamination, somebody diagnosed with COVID-19, somebody on another floor diagnosed with COVID-19, and it might have gotten through the HVAC system, you're going to want to make that point in making your claim. Because remember, direct physical loss is the requirement here. So if your office is contaminated, really contaminated by COVID-19, is it a direct physical loss? Well, an insurance company is going to say, if your loss can be cured with a Clorox wipe, it's not a physical loss. It's not physical damage. In fact, if the virus lives for a certain amount of time on a surface, 12 hours, 24 hours, 72 hours, whatever it is, after that period it dies, the insurance company is going to say, your office can essentially disinfect itself. That is certainly not a physical loss or physical damage. Now, the position you may want to take as an insured is that direct physical loss should include a situation where your office becomes uninhabitable, unfunctionable, unoccupiable, and possibly even deadly. You might argue that that is direct physical loss or damage. So I don't think that insurance companies are going to give this point away freely because business interruption coverage has always hinged on direct physical loss. So the only way that this interpretation in the policies starts to get interpreted more liberally will be through lawsuits in the future, and we'll have to see how the courts approach this issue. And again, just going back to this issue of direct physical loss, if your office was not contaminated and you just had to shut down or modify your hours based on trying to stop the spread of the disease, I do not see that as being a direct physical loss, and I see no coverage under a policy in that situation. So one other thing I wanted to cover was that in many business interruption policies, there are provisions for what's called a civil authority shutdown. And this is somewhat appealing in this kind of situation because we certainly have a situation where our governments have shut down businesses and ordered non-essential businesses to be shut down, modified, restricted. And so you might be wondering if under your business interruption policy, you have recourse under these civil authority provisions. This type of provision expands business interruption coverage to apply to situations where access to the insured's property is prevented or prohibited by an order of a civil authority issued as a direct result of physical damage caused by an insured peril to other property in the proximity of your insured's property. So, for example, a much easier example to understand is if there's a gas explosion not on your property, but the property next to yours. And perhaps the authorities have restricted access to the whole area, even if your property wasn't itself damaged. Perhaps there's been a restricted access and your business has suffered an interruption because you've been shut down. In that type of situation, you might see the civil authority provision kick in, and there could be coverage under your business interruption policy. So can we apply this civil authority provision to losses sustained by COVID-19? In other words, can the government orders that have resulted in the closure or modified operation of your business qualify as a triggering event for coverage under your BI policy? And so it depends, of course, on your policy language and on the insuring agreement, because there are different issues to consider. First of all, whether the physical loss or physical damage definition applies in the civil authority, because you have two different areas of damage right now. You have whether or not there was physical loss or physical damage where the incident occurred. And then you have the condition of your own property. So physical damage may or may not, depending on the terms of your policy, be required to your own property, but it may be required at the area where the incident occurred. So after you establish whether or not there has been true damage to the adjacent property or the property in proximity and your own property, you then have to look at whether or not access to your own property has truly been prohibited. So as I thought about this, I thought, you know, if you have a restaurant right now, you might think access to your property has been prohibited, but it is not truly prohibited because you're probably allowed to do curbside or takeout. So it's been restricted, but it hasn't been prohibited. So there are going to be hurdles, highly dependent on your policy language, toward applying these civil authority provisions. So to summarize, first, the civil authority provisions to apply, you have several qualifications before you can trigger coverage. You need damage to property other than your own that was caused by a covered cause of loss. You need access to that other area to have been prohibited by the civil authorities. An action of a civil authority had to have been taken in response to the dangerous physical conditions that were at the property in proximity to yours. And access to your property has to have been prohibited. So you have to fulfill those 4 requirements based on the COVID-19 virus. So it's a tall order. And again, it is highly dependent on your individual policy language. So when we discuss the various levels that you had to analyze policy provisions on, we talked about the insuring agreement, falling within the insuring agreement. That would be either on the business income or on the civil authority that we just talked about. And then we talked about step 2. If you do manage to fall within the insuring agreement, did you fall within an exclusion to coverage? If you are within the insuring agreement and there is no exclusion, you have coverage. If there is an exclusion, then you go to step 3, which was, am I within an exception to an exclusion? If you're accepted from an exclusion, you have coverage. If not, no coverage. So let's talk a little bit about exclusions and exceptions. The absence of the exclusion does not create coverage. Coverage is created by the insuring agreement. So that's why we have this premium on establishing the physical loss or the physical damage. In recent years, and particularly after the SARS epidemic, insurers added exclusions to their policy based on exclusions for losses based on viruses or bacteria. And from talking to people in the industry, it seems that 50% or more of business interruption policies contain an exclusion for losses caused by viruses. And so if your policy has an exclusion for losses caused by viruses, and there is no applicable exception to the exclusion, there is likely going to be no coverage for your business interruption losses. Note that I have looked at least one policy that contains an exclusion for bacteria, but it did not contain an exclusion for viruses. So in that case, I would argue that there's no applicable exclusion because COVID-19 is a virus and it's not a bacteria. There are other applicable exclusions that may or may not exclude losses based on COVID-19. One of them is contaminants. You should look at your policy and see if it contains an exclusion for losses caused by contaminants. Now, courts have fallen on both sides of this issue as to whether or not a virus is a contaminant. I've seen the cases both ways, so you have to look at the definition of contaminant in your policy, and we also have to kind of let the courts run their course on this issue and see how they decide it with respect to COVID-19. You may also have an exclusion based on pollutants. Is a virus a pollutant? My personal opinion is no, because I think of a pollutant as being a more unnatural element, but some definitions for pollutant within policies include contaminants. So depending on your definition of contaminant, maybe a virus exclusion, maybe viruses can be baked into an exclusion based on pollutants. So overall, I think what we're looking at is these policy terms vis-a-vis COVID-19 losses are going to have their day in court, and we're going to see how the courts interpret these policy provisions. And experts tell me, including maybe one or two who may be on the phone with us today, that we can expect insurers to modify their policies as a result of COVID-19, most likely by increasing the frequency of virus exclusions, and also perhaps by providing sublimits for damages caused by viruses, which means that there might be a specific coverage limit for any claim you can make for losses caused by viruses. So one thing I wanted to get to here at the end before we take some questions is you may be thinking, if I want to make a claim, do you have any tips for me? And I thought I'd put together some practical tips for making a claim. And my first tip is that policies are hard to understand. The language is really complex. And so I think a good starting point is always to call your agent. There are some fantastic agents around here, and hopefully you bought your policy through one of them. We have Rand, we have Abercrombie, we have JW Allen, we have some great folks around here. These people are more knowledgeable about insurance policies than many attorneys. So I always think it's a good idea to start with your agent. Another thing you're going to want to do is look in your policy and see if there's a time limit from the point of the loss sustained to make your claim, because you don't want to fall outside of that time limit or it could be time barred. You're going to want to make the claim if you had actual contamination of your premises, if you had an employee or yourself or someone in your building who was actually diagnosed with COVID-19, because like I said before, I see this as an area where there could be some wiggle room to argue that that was a direct physical loss or physical damage. Now, after you make the claim, you are likely going to get acquainted with what's called a reservation of rights letter, what we call an ROR in the business. So a reservation of rights letter is a very detailed letter from your insurance company saying that they are either further investigating your claim or that they are denying your claim or reserving their rights to deny your claim or somehow otherwise restricting coverage. And the reservation of rights letter will set forth the specific policy provisions on which they are relying in either investigating your claim or perhaps restricting coverage. So you're going to want to take that ROR letter and read it yourself and take it to your attorney. And when you do talk to your attorney, make sure you talk to an attorney who has some experience in coverage work, because it tends to be its own beast in terms of the practice of law. As a last point, you might be wondering if I've completely deflated any hope you have of making a claim under your business interruption policy. What can I do to try to recoup some of these losses? And I think that when the lawmakers enacted these provisions under the CARES Act for the Payroll Protection Program and the Economic Injury Disaster Loan, they enacted those programs in part because they knew the limitations of business interruption policies, and they knew that it was going to be hard to find coverage for losses caused by the COVID-19 virus under these BI policies. So I hope that you're all making applications for the Economic Injury Disaster Loan and the PPP. I know that the money hasn't really started to flow yet, but get in the queue and hopefully there'll be some recourse under those programs. So I'm open to questions now, if anyone has any.
Yeah, Felicia, do you want me to, I can ask the questions.
That'd be great.
We have a few over here. Felicia has a question, and it's, is the government encouraging insurance agencies to cover this? Also, what should we do going forward?
Well, I have read some articles in the journal about some lawmakers trying to pass legislation mandating that insurance companies cover this type of thing. I personally don't see it going anywhere, because I think that if insurance companies are forced to cover something that they did not write the policy to cover, it's going to shift the burden, perhaps unfairly, onto them. I know people aren't fond of defending insurance companies, but if the insurance company wrote the policy for a certain type of loss and unexpectedly another type of loss is shifted onto them, it's not what they were intending to cover when they issued the policy. And it will also, if such an effort had success, it would also, I think, make insurers hesitant to issue these types of policies in the future, because they would think, well, this policy isn't worth the paper it's written on if lawmakers can just pass a law and make us cover all the losses anyway. And so in terms of where we are going, the second half of Felicia's question, I think that we are going to see the COVID-19 virus change this type of insurance policy going forward. I think, like I said, that we're going to see a lot more virus exclusions, and we are going to see a definition of loss that is very careful about excluding any loss pertaining to viruses.
Well, does that mean that consumers will then have the opportunity to buy a rider, you know, for virus-related business interruption? Can we expect that?
I would think so. And maybe if we have some insurance agents on the line, they can answer that. But I would think that there would be endorsements or riders made available to people who want that kind of coverage. And of course, it would come at a cost, and that's the way it would be. But I would hope that such a thing would be available.
This is Leslie. I would expect that there will be available riders or endorsements to policies in the future. Clearly, this is going to go to the courts. As you've very clearly outlined, Kelly, there's nothing clear right now about a pandemic or a virus in the policies. In addition to that, it's a big amount of claims. The industry is not sure that they can even bear at this point. If you put all the small business claims out there and put them all together, industry doesn't have enough in reserve to probably even cover all the small claims. So I'm sure it's going to end up in the courts, as you've said, as it did with SARS. But I think in the future, there will be available endorsements on high-end policies for things like this. We're all learning, it's all brand new. So it's brand new to the companies as well. What I would advise, as you said, is talk to your agents about how to make the claims. We do very little business interruption at JW Allen, but what we have been doing is, as you've said, if there was somebody who was directly affected by the virus, that can potentially help, but it's really sort of trying to find what the language is in the policy and then gear your claim towards that.
Thank you.
Do you have anything to
I have
add?
another
That's
question
great, Leslie.
from Ginny Hull Heartline. Verbiage regarding natural disaster. Is that always weather related?
And I'm sorry, Alexis, because you cut out for me during that. Can you please repeat it?
Sure, it's from Ginny. What about verbiage regarding natural disaster? Is that always weather related?
That would depend on the exact terms of the policy. So you're going to want to look at your policy. At least one that I've looked at certainly contained exclusions for earthquakes and those types of natural disasters. But the policies they have to be read very carefully, because sometimes, for example, flood might not be covered, but if you had, bacteria and rot that resulted from flood, then that might be covered. So you have to look at the particular language of the policy and how it defines acts of God, force majeure, those types of provisions.
There is a lot of variation in policies. Some are named perils, and so they are very specific about what kind of perils they will cover, where other policies might be all risk, still exclude certain certain things like flood, as Kelly mentioned. So the policies vary enormously sometimes standard, but they vary depending on the carrier that you're with. So it's, unfortunately, you gotta look at the language.